But what are the consequences going to be for the people who were deported because that could have taken advantage of this, even after Pereira set the tone and the BIA came back? So is there going to be a reopening of these old cases, or how does that all going to work out?
Yeah. Attorney General Greg said, if I was Attorney General, I don't know. I think there's two issues. The cancellation removal stuff, that's solid to me. Answers the question. 10 years continues to run. So how does this affect motions to reopen, and how does this affect jurisdiction and motions to terminate? Hitting up motions to reopen first, I think that there's a very strong argument for motions to reopen, whether it's sua sponte, which means just on the BIA's own authority or an immigration judge's own authority, or regulatorily, with an argument that the 90-day deadline to file that motion should be equitably tolled. By the way, the equitable tolling 90 days probably started on Thursday, so, heads up. But, because this is not about retroactivity, this is not a new rule. This is Justice Gorsuch and the majority saying what the statute has always meant. That is, and some of this language in the decision, there's strong arguments that cases should be reopened for non-citizens who were found statutorily barred for cancellation, even if they didn't apply. My partner, John Pratt, noted in Justice Kavanaugh's dissent, Justice Kavanaugh says Mr. Niv Chavez didn't even apply for cancellation. Mm-hmm. I don't know, quite frankly, I'm not sure quite how he managed to get before the Supreme Court and how he got it exhausted, but Justice Kavanaugh said he didn't even apply. So if you file a motion to reopen saying my guy didn't apply because the 10-year bar precluded him, but now he's not precluded, file that motion to reopen, include your 42B and all of your evidence, but file that motion. And by the way, there's a 10th Circuit case from 2 years ago that may provide arguments for if the qualifying relative child has aged out since. Now, that's a motion to reopen that very well might fail, but it's out there.
It's just like both BIA and IJs have like huge backlogs. So, like getting this motion reopened, and I don't practice that area, so I'm kind of guessing, but just practically people knowing that to do this, how much it's going to cost to try to fix this is just such a nightmare if you're caught up here with the applicant. So, but hey, for your phone here.
All of this is right. It depends whose side you're on. If you're caring about efficiency and getting the backlog in immigration court down, then it's an absolute nightmare. But if you're a non-citizen who is about to get deported, it's a lifeline.
My worry is that the people who already lost it, now they go back to the system, they probably are deported, they have to go open and reopen, and they are in the country, might be from countries where they might get killed or something like that. So it's like these are really life and death kind of consequences for the actions of the bureaucracy misreading a statute like this. Or being late, just being able to create a computer system that could work with the IJ's calendar properly.
Yeah. And whether or not you can file such a motion to reopen if you've physically been deported already is a even more complex question, because there are bars to filing motions to reopen if you've been physically removed. But then that whether or not that actually applies goes from statute circuit to circuit. These are big motions. This is a big issue, and practitioners need to charge accordingly because. And everything implicates ineffective assistance of counsel now. If you've got your case and they might be out, if you have an active case and you don't apply for cancellation now, you are setting yourself up for ineffective assistance. And if that 90-day equitable tolling clock started on April 29th. So look at your cases. That's the ugly side of all of this, right? There are arguments for ineffective assistance.
Well, yeah. So we got to make a clip of this just two reminders to people to get up and check their caseload. But now there's another case that you mentioned before you talked about that affects my caseload, benefits-based USCIS kind of cases. Was that a Supreme Court case as well?
No, it was a board case. But before I jump away, just if I could say one more thing about Ms. Chavez is how does this affect motions to terminate? Does this change all the case law out there that said notices to appear are not jurisdictional? And so removal proceedings can still begin even with a non-compliant NTA.
So it just affects the 10-year the clock, but not necessarily that they have to appear kind of thing.
Right. All of the circuits and the board rejected the jurisdictional argument, and some found it was a claims processing rule framework. We've been now for 3 years. Other attorneys might disagree. I know people are still already filing those motions to terminate. I think judges might have already granted some, but I don't see a change. But, still might be filing some motions. There's certainly arguments, and I'll get into the reasons why and some of the quotes on the podcast on Monday.